counsel, witnesses, and jurors. Your Honor, you restricted it when you signed this order. Not only, what makes this so disgusting is he consented to this order. So this wasn't even put upon him. He agreed to this order. They want to tell you about 5 days. Those were 5 days he chose. They know that we tried to work with counsel, but that's irrelevant. He was given the benefit of the doubt. He was treated like every other defendant, although he had an open case. He was given an opportunity to cooperate with the rules of this case. And what he really did was spit on the court and refuse to oblige by 3 of the 7 conditions of this bond order. So no, he does not have the right to communicate about facts of this case with witnesses, which he did with Jenna Ellis, which he did with Sterling, which he's very well aware of and was served. And it is not the state's fault if the defense is unprepared, which was their argument. We're unprepared. We don't know what's in the discovery. Not my problem.
How is he communicating with Ms. Freeman in this post?
When you put something on a social media page that's reviewed by 400,000 and you put it in an open space, you have the ability to indirectly communicate with Ms. Freeman when you put it in the public space. Perhaps they could have some sincerity in that if he had a closed page that was not watched by many. Do you understand what I mean by a private or a closed page? That is not the status of his post, which is why close to 500,000 people saw it. Again, response, mentioning Jenna Ellis. Again, I guess they want you to believe they don't know Jenna Ellis is a witness in this case. On and on, Your Honor, and you have it. And again, I don't want to waste your time. And the response is just what you could expect. Ms. Ruby needs a bodyguard or she's going to get Epstein. This is a direct result of his conduct, which is why you as the trial court have a duty, and in fact did your duty, to keep witnesses in this matter safe. Moving right along, if she'll live to see this day, there's no denial that as a result of his conduct, a witness was put in greater harm and greater hate was again spewed against someone that's had to go through this for 3 years. Condition 6, he shall not communicate in any way directly or indirectly about the facts of this case with any person known to him to be a co-defendant in this case. I guess they want you to believe they didn't know Jenna Ellis was a co-defendant. You can look at the post. It's part of the record in here. Jenna Ellis again saying she saw it, which means there was an indirect communication with him. Your Honor, I just need to prove he violated the order once. He knew what he was doing. They signed this order. They agreed to it. There was a good reason to have an order with these conditions. And what we're really here to decide today is, does this order mean something or not? He doesn't get a, oh, I'm sorry, after I've already intimidated the witnesses in this case. It's too late. You should not have done this. You knew it was against the rules. You put someone in danger as a result of doing it. And now you need to be held accountable for it so that we can make sure that all of the defendants in this case get a fair trial and that witnesses are kept safe. Moving right along, Your Honor, you'll have all of these in your communication. There was some debate, again, lunacy and absurdity, that we don't know if this is Harrison Floyd. Your Honor can look at the post and see his image tying this to him. Jenna Ellis, again, in these posts. Authority of the court. Bonds in both felony and misdemeanor cases may contain conditions so long as the conditions are reasonable under the facts and circumstances of the case. I would suggest the conditions you gave him were reasonable, which is why they signed up to them and agreed to them. And Your Honor, it is not, we limit Fourth Amendment rights all the time in giving bond orders, giving someone the right to search. Same thing with First Amendment rights. Authority of the court. One of the court's functions is to balance the defendant's rights with the interests of the public. The public is Ms. Freeman, who served, keeping her safe. The public is also Ms. Jenna Ellis. The public is witnesses and jurors who will come and testify. Here, the bond conditions are not arbitrary and capricious because the conditions are a reasonable response to the trial court's functioning of balancing the defendant's rights with the public's safety interests while avoiding the intimidation of prosecution witnesses, which was the exact purpose here. But Your Honor doesn't have to find it was intimidating. You can say, you know what, calling witnesses pieces of shit, it don't even matter. I don't find that to be intimidating. Do you find they communicated? Do you find that they communicated with co-defendants? Do you find they communicated with witnesses? If you find that, then you find that he violated the bond order, and you have to decide, do we have an interest as a society in keeping witnesses in this case safe? Do we have an interest in this case of keeping the other defendants from having a fair trial? Authority of the court. Although litigants do not surrender their First Amendment rights at the courthouse door, those rights may be subordinated to other interests that arise in this setting. For instance, on several occasions, this court has approved restriction on the communications of trial participants, which he is, where necessary to ensure a fair trial for a criminal defendant. There are other criminal defendants in this case. In the conduct of a case, the court often finds it necessary to restrict the free expression of participants, including counsel, witnesses, and jurors. Again, the site for that is Seattle Times versus Reinhart, 467 U.S. 20, 1984. Defendant Floyd violated his bond and it should be revoked. OCGA Ayala sets out 4 factors a court must consider when setting a bond, including he violated 3 of the 4. His rhetoric poses a significant threat or danger to witnesses in this case and the community. He poses a significant risk of committing a felony committing trial. He poses a significant risk of intimidating witnesses and otherwise obstructing the administration of judges. The absurdity of the defendant's argument. Defendant falsely claims that he does not know who the witnesses are. Your Honor, that's just a lie. It's just a lie. There's no other thing to call it. You're not aware Jenna Ellis is a witness? So I know that it annoyed you to ask that question, but I wanted you to see in their own motion, they know she's a witness and they should not have told you that. Defendant Floyd in his own motion refers to Jenna Ellis as a witness. Defense motion, page 8, line 9. Defendant Floyd in his own motion refers to Ruby Freeman as a witness. More absurdity. In indictment number 231888947, Ms. Freeman is mentioned 40 times, but putting the defendant on notice, she is a witness. In indictment number 23SC18947, Secretary of State Raffensperger, who he tags, is mentioned 4 times. I think that puts them on notice that he's a witness. The defendant has the witness transcripts of the Secretary of State, Mr. Gabriel Sterling, and Ms. Freeman. They are aware with these witness statements that they are witnesses. Defendant states in his motion affirmatively that Mr. Floyd's post did not stir the pot against Ms. Freeman. Really? You saw the post. It absolutely stirred the pot. And so for them to put that in their post when they saw, as he called them, the ugly, racist, violent comments, that is a direct result of his conduct. However, a cursory review of the response to Mr. Post show that this to be another lie. Miss Ruby needs a bodyguard or she's going to get Epstein. Ruby is, if she lives till a trial. I'd love to see her daughter in the slammer, 2 corrupt losers, up to it, bury this under the jail. Ruby should be in prison. She's a racist. Because he's the one that's scared she's afraid of white folks. Racist pig. It's no question that that is not true. Dirty damn rats. All of it is untrue. So they should not have stated it in their motion. Defendant wants this court to believe when you tag someone in a post, it does not notify them. The entire purpose of tagging someone is so it hits their feed and they see the post. Take judicial notice of that, Your Honor. You don't even have to, though you have witnesses testify to it. They make this silly argument because it is clear that it's communication in violation of the bond order. They know it's communication. I'd submit to you it's direct communication. But it doesn't matter. If it was direct or indirect, he violated his bond order. In 2020, Ms. Freeman and her family members were intimidated by people as a result of her name being disclosed on social media. And it is this intimidation which Mr. Floyd was indicted to represent to the court that his recent post of accusing Ms. Freeman of the exact same things that were done before and indirectly targeted Ms. Freeman is absurd. Defendant wants this to court to believe that the last thing Mr. Floyd wants is for Mr. Freeman to form an impression he's somehow against her, except his post show that. Yet it is Mr. Floyd accusing Mr. Freeman of his post of being a fraud. Your Honor, all we're asking you to do is exactly what the defense asked you to do. Read the court order. Look at the evidence. He violated this court order. It is unfair to those witnesses that are just coming, first, to do their public duty as an election worker, and second, to do their public duty as a witness. And there are real consequences for allowing defendants to intimidate witnesses. Your Honor, we're asking that his bond be revoked and he be remanded today.
All right, I'm going to allow the state the last word, but Mr. Kasparov, if you have a few other points you want to make.
Yeah, I'll be brief, Your Honor. Your Honor, as you know, I've not ever contended that Ms. Ellis isn't a witness or that we didn't know she was a witness. I'm not sure where that came from. My motion said, our opposition says she was a witness. We admit that. The state's argument is that anything on social media posted about that Harrison Floyd posted about this case is automatically an indirect communication, if not a direct communication. That's absurd. And that's where we're running into trouble here. Judge, I would submit you focused in on one particular tweet, which was Jenna Ellis. And I'm going to go back to her tweet. That tweet is a shout out to the Twitterverse at large. Yes, I think it walks up close to the line, but if you understand the world of Twitter, or X as it's now called, that's not how people communicate. It's a very ineffective way to communicate. If he really wanted to communicate with her directly, he would have simply sent her a notification and called her a liar or whatever. And he could have even called that out. That would have been a clear violation of the protective order. The other point that the district attorney made was that, oh, we said we didn't stir the pot. Yeah, we didn't stir the pot. You see, the district attorney stirred the pot. They've been stirring the pot since he got arrested, Judge. From the very first occasion, I never got a call about Mr. Floyd getting bond. Rather, I have Ms. Willis and Mr. Wade apparently recorded my colleague up in Maryland, which, by the way, it's a two-party state. It's a felony to record without permission up there. They recorded my colleague, and he said, I don't know anything about the bond. I was handling his case to come here to Georgia. So this idea that he's been given all these chances, et cetera, I think that's hogwash. Now, this idea, though, that we didn't stir the pot. All the evidence that you have, the views, they are wholly dependent, Judge, when they were captured, when you looked at Twitter and when you captured that image. When they filed this motion to revoke bond, just like when they filed the motion for the protective order, if you recall, Judge, I was in court and I said we had gotten numerous calls from the media that they were pestering us, and you said, well, we should all expect some of that. And I agree, we should in this case. But this is not exactly right, because when they file a motion to revoke his bond, they're all in the back watching us. When they file the motion, it immediately causes a spike and everybody starts searching everything. So they can't use that as evidence against Mr. Floyd. I think that is absurd. The other thing I would leave you with, Judge, I really believe that the words of this court order are pretty clear. And I think the only thing that you have to discuss or to analyze today is whether you believe he was communicating with Jenna Ellis in that one post. I think that's the only issue that you are faced with, because it's an indirect tag. Now, it's not an indirect communication, and as I've said, the Twitter help file is just dispositive on that. It's a shout out to the Twitterverse. Could it be used as a direct communication? Well, indirect. I'm sure it could be used as an indirect communication. But if you search yourself, Judge, and look up Jenna Ellis and send the money back, I think she raised over $200,000 and before she entered her plea, you'll find hundreds of thousands of posts telling her to give it back. Now, maybe she was directed to Mr. Floyd's at some point by the state. I don't know. We don't, and we should not chill speech. He has the right to make political speech. He has the right to talk about the facts of this case in Twitter, as long as he doesn't communicate with another defendant or witness. Now, we don't know all the witnesses that are in this case. Like I told you before, I know a fair number of them, but I have a list of unindicted co-conspirators that I'm just trying to figure out who they are. We don't exactly know. I don't have a matrix of that. If we do, it's in the discovery somewhere, and we're still searching through that morass of information.
So you were not provided the witness list used during the trial we had prepared for Mr. Chesbrough?
No, I was not, Judge. I don't recall getting that list at all.
All right.
If they did, I couldn't sit here today and tell you they didn't put it with this mountain of stuff, but the way they turned over discovery, I've never seen anything like it. They just handed, 80 folders down, yet you find this one little GIF image, a little picture that belongs to another file that's down a different tree, 50 folders. It's absurd. That's absurd. So at the end of the day, I think the rule of lenity is appropriate here. You know, if the court feels that something is amiss, or you want to correct something, or we need to make something more clear, I think we need to give Mr. Floyd the benefit of the doubt. This is not giving him a second chance. I'm not asking for that because I don't believe he violated the words of the bond order. I think the bond order is crystal clear. Do I think he walked up close to the line? Yes, he did. Have we had discussions about it? Sure. But in terms of the last part with the 13th and 14th, when we were accused of, quote, leaking a video, that video wasn't leaked. There was no protective order on any of those proffer videos. That wasn't even a leak. Yet Mr. Floyd's November 13th and 14th posts are responding to that purported leak because the district attorney absurdly put in that a typo from my colleague where he said, we are the source of the leak. And he then sent another email back pretty quickly that said, we are not the source of the leak. I'm sorry, that was a typo. I typed too fast. They did mention that it was a typo in their motion, but they only included one email. The press picked up on that one email and things started to go crazy. That's the nature of this case. So if we're going to limit speaking, you know, every time Miss Willis goes to Washington, D.C. and attends one of these events, we get spikes in Twitter. The same time that he was making these other comments, that's when she was in D.C. at these events. So the words of the court's order are clear. The burden has not been met by the state for the, and I'm positive the burden has not been met for the concept of intimidation. That's a legal definition under Georgia law, and it requires one to be objectively and put in reasonable fear of harm by the words that were spoken, not by responses, not by any of that stuff. And then with respect to the last two, paragraphs 6 and 7, you won't communicate with. It means alongside, I won't go to this man and say, I communicate with you. I want to talk to you. As opposed to me addressing you here, knowing full well he can hear me. And saying, well, John Morrison is our co-counsel. I'm not communicating with him, but he can hear it. So the idea that he didn't communicate with about the facts of this case, as I want to express to Your Honor one more time, it's not that he can't talk to a witness or a co-defendant. What Ms. Willis said about that is absolutely incorrect. That's not even what the court order says. The court order is specific. You cannot talk to another witness or co-defendant. You cannot communicate with them about the facts of this case. The whole purpose of that number 6 and 7 is to avoid collusion. That didn't happen here. What we have here are First Amendment issues. If you want to curtail, I would submit, Your Honor, we should adopt what the president's bond conditions, where they explicitly mention the First Amendment issues on Twitter, because the president is known for that. So if they felt that this was included in his bond motion, they should have put it in there. They had the opportunity to do that. Thank you.
Your Honor, I'm not going to be long. The bottom line is the defendant didn't respect the order of this court. He violated it. If you have questions about intimidation, don't go to that paragraph. Go to paragraph 7. Although you have a witness, Ms. Jenna Ellis, telling you she felt intimidated, and Von Du Bois, who represents another witness, telling you that he interpreted that his team, to include his client, interpret that as intimidation. But you don't need it. All you need is paragraph 7, which says he's not to communicate. This notion that tagging someone doesn't get a message to them is really lunacy.
All right. I'm going to compile my notes and I'll be back in 5. We can hold in place.
Right, exactly. I'm gonna get a power strip.
Yes, he did say 5 minutes. 5 minutes. About 2.5.
Bill Wooten, W-I-L-L, W-O-O-T.
Wooten.
Yeah, W-O-O-T-E-N, T is in Tom, E is in Echo.
Is that
Nancy. Yep.
Okay, and that's Mr. Wade.
Yes.
First name.
Nathan.
Nathan Wade.
N-A-T-H-A-N. I don't know. I've been trying to find out.
I'm sorry,
Your name.
Daisha, D-A-Y,
Daisha.
D-A-Y-S-H-A.
S-H-A.
Middle initial D,
Daisha
D, Young.
D. Young.
Yes.
Young. All right. That's good.
D-A, I think it added an apostrophe in there, D-A-Y-S-H-A.
Deja. Like that?
There's a Y after that.
Yeah, I don't have. D-A-Y.
No objection.
Deja, okay. Take that.
Yep.
No, you can just put them up there. He has them anyway.
All right.
Fix that. We're good? ADAs.
We all have different titles, but that'll work.
Well, titles are important. Google.
Look at my Oh, okay, my bad.
You see that shoulders just came out? Like one up.
Tough breath.
But when all come to order, remain seated.
All right, thank you all for your patience. So just a few thoughts to share. And the first, I would just say how we got here. At the outset, I'll just note that at the time of indictment, we were in this courtroom in the middle of another murder trial, so I was not able to conduct the first appearance for Mr. Floyd. But throughout that week during the trial, we were presented with these consented bond orders, which were negotiated by the parties, and that I signed without a hearing. And Mr. Floyd agreed to abide by the terms of it. And I think it's clear from the case law, there is no constitutional right to bail. And a bond can contain special conditions as long as they're reasonable under the circumstances. And often those can curtail or even eliminate defendant's constitutional rights under the First Amendment, under the Fourth Amendment, such as forbidding contact. We see that quite commonly. And the question becomes, a trial court has to balance the rights of the accused, as well as the public safety interests that are raised by any particular case. But I'll also note that a defendant is generally allowed to publicly criticize the merits of a case, to say that the prosecution doesn't have a case, to challenge the strength of the evidence, to speak his mind. And I don't see anything in this consent bond order that limited general criticism of the state's case. Each of these conditions had components to them, had preconditions, but there was no general limitation of talking about this case. But obviously that criticism cannot cross a line and ever evolve into witness intimidation. And I think, as the defense was willing to concede here, Mr. Floyd seems very boldly willing to explore exactly where that line lies in this case. And I think the state has made a compelling argument on many of these points. But in categorizing these statements, on the first point of intimidation, we don't see, as we might see in these bond conditions, as they're traditionally understood, someone posting the personal info of a witness or a co-defendant. We don't see someone directly messaging, again, as that's traditionally understood. And we don't see in the wording an explicit indication that something ought to be done about these individuals or that they should be targeted in some way. I read these as seeing more that someone is wanting to defend his case in a very public way. And so on the question of, and especially when it comes to the public officials, I think we've, as Mr. Sterling testified, when it comes to intimidation, they've endured far worse than is presented in this motion. I think it becomes a much closer question when we start talking about whether this is direct or indirect communication. And we're getting into also kind of a question of, at what point is someone responsible for the response of others? And I don't know if those are necessarily settled questions under the traditional bond limitations that we used and the phrasing that we used in this case. And ultimately, I think that, first of all, the defense argument that there was no knowledge that these were potential witnesses, that's not an argument that I'm buying. I think that we can't hide behind a veil of ignorance when certain witnesses have testified before the special grand jury or are very much known to be involved in the facts of this case, or just recently pleaded guilty and were known to have a public cooperation provision. I also think that when we're talking about the facts of this case, that is a broadly understood term. And if someone is just denigrating another person who's known to be a witness and talking in reference to their proffer, that's also satisfying that precondition. But when it comes to the question of indirect communication, again, I think it comes down to, while there may, I do think that in several instances here, there has been a technical violation of Mr. Floyd's bond, and that communications he made wound up before the eyes and ears of potential witnesses and co-defendants. But not every violation compels revocation. And so I am stuck on the question of notice, and that the bond conditions as written in my mind were not specific enough to account for the nuances of social media. So I think the ultimate result of today's hearing is that it's very clear to me that this bond needs to be modified. And I think it needs to specifically prohibit any public comment concerning Ms. Freeman, concerning her daughter, and concerning other witnesses that need to be included, because even if he's not directly or indirectly communicating with him, however we define that term, I think the public safety interests raised as a result of today's hearing indicate that his actions have a consequence. And because he's under the conditions of this bond order, the court has the ability to curtail and protect that interest. So ultimately, what I would be asking for is for a recommendation from the state, but I would also allow the defense to respond of exactly how they would propose adding or modifying these bond conditions. And I will then take those under advisement and enter a modification on the record. And nothing from today's hearing should be seen as curtailing the state's ability to refile such a bond revocation motion immediately upon an additional violation. And I think that it also is very much dependent on the specific facts of the tweets and communications at issue here. And it can't be so broadly defined to cover all other co-defendants. So on the issue of modification, I think that's something that we can revisit and let time to consider, unless there's something the parties would like to address now and want the court to be able to consider specifically what they would like to see as a modification, or that's something we can follow up, but the court is available and ready to enter that as soon as it's conveyed. Anything, Ms. Willis, that you would like to add?
Obviously, we're very concerned about the safety of Ms. Ruby Freeman. She has clearly endured enough. And this conduct is not just chilling to her, it's chilling to other people who would want to serve in her capacity. So, you know, we respect the ruling of the court, but take exception. This defendant is very well aware of what happens when he tweets about Ms. Freeman. We do not believe it is appropriate for him to make derogatory comments about anyone. He can publicly criticize me all he wants. I don't value his opinion, it doesn't matter. But what he may not do is publicly do things that intimidate witnesses. And so that needs to be clear. He should not be able to tag them so that they are communicated with, or put them in open space so that Ruby Freeman now may have to move again and get another advisement from the FBI. And so I would ask that before Your Honor leaves here today, that my team be allowed to sit down, that the defendant personally sign off on an agreement stating that and initial each clause, so that it can be made more clear that he should not contact and intimidate witnesses in this case.
I don't have any concerns with what you've raised. Mr. Morrison, Mr. Katroff.
Briefly, Judge, I'm not going to sit down and initial language that I haven't seen, number one, or had time to look at, cogitate, ruminate, pontificate over. I think the appropriate thing for us to do is what you've suggested. We'll submit our orders. If you take what you think is appropriate and reasonable and enter it that way.
Well, then I'd ask you stepping back today, and then when we can get it worked out, then he can be loose.
Well, I think there's still time to the day. Why don't we see how far we get? I'm not going anywhere. And again, I don't think we're writing a treatise here, but I think there needs to be something more explicit and a little bit more definite, and it can be as all encompassing as we need it to be. And if we need to go back on the record about that, we can. So how about I will check back in with everybody closer to 5, and we'll see where we are. And if we need more time, we can take more time.
Your Honor, does the court have a jury room where we could meet?
We do have several rooms. I think the state could use the jury room if they'd like to, and we can find a side room here if we can unlock that for you. Deputy Scott, is that unlocked? All right. All right. So the adjoining courtroom is also open.
I guess, look over some motions.
All right, how you been? Good. Long time no see. That's what we're talking about. So you said you got your own.
Oh my God, there's one that's not happening. No, I will be gone.
Well, what's? Yeah. So.
Sure.
Both sides, yeah.
So then I was up until. So. Okay, I like so embarrassed now. Everyone heard my story about the case.
I was gonna come up today.
I was going back and forth.
Diary. I was. I'll see you around.
Get back on when.
Well, I got 80% left, so I mean, if I need to change, I'm good.
Okay, if not, just, you can, I mean, it's 4:30, so it'll be.
How's everything look?
It's good, it looks good. Okay. And we are commenting on his brief too. Alex.
Yes, it is. Thanks. No, I appreciate it.
I'm gonna always got, okay, okay. Go now real quick. Okay. Go now real quick.
It's so funny because I thought it was gonna be eBay. Because I was like, oh, it's gonna be like 30 minutes. So I just-
Hey, did you see him? Yeah. What is that? Same. You can stand inside, move your hands. I guess 45.
Can you tell us in the back end service on the 82 leaving 901 Rice Street to the Atlantic City Detention Center? Two female inmates. Mama giving mileage is 088527. Real service, sir. Alexis, where the camera radio?
Yeah.
Thanks. Yeah, thank you.
Hey, Jerry, you gone?
Yeah, I'm out, brother. Make sure you
I'll
call.
call you tomorrow. Yeah. Awesome. All right. I'll be back. Yeah. I didn't want to buy two. I posted one. So I trust. That's a good story.
Tomorrow. Yeah. So it's just I was like really lucky to still be together and stuff. I guess we're for 2 years. Too, but like it's like small town. I think it's just like probably seeing the view like not from small town, but like a smaller town. Yeah, definitely. Like mid, yeah. It's gonna be like I'll be here on the 15th. Yeah. Last time I was oh, really? Yeah. So it's not one of those things where you have to be there, like district court stuff. They are. So last time I came stuff. He was only and it's just like my preference. It's really be able to describe like judges, their rigor. It was really hard to certain or couldn't tell the difference between two judges in terms of the voices. Just don't know. So funny. My mom will love her. This dress. I don't have to find the picture. I was telling her, don't have Stop. It's like, he's like, you look at that guy. You're usually cartoons. Yes.
I like those shoes, man.
Really
These I had a pair of those and I couldn't find those. Adidas, right?
No, these I think they're the Air Max.
Oh, yeah, Air Max.
Yeah.
Nike. Adidas had a pair similar that I wore maybe about 4 years ago. And I tried, for some reason, all of Nike was a Nike. All of the Nike shoes were now. They got a pair out now that costs about $160 or $170. Love the way they look, too tight. They comment on this green outfit. Everybody, yeah, lucky talk today. Yeah. It's like crazy. It's like, well, I'm on vacation after this. Tomorrow through Friday, then I got to do the Georgia game. We're gonna do like a show before the game, like a 30 minutes to an hour show, probably an hour show before the game starts, because it's on our network. What was her first name? So, Amen. Hey, can you run me the battery?
One six four nine radio. 1649. Anybody 0888531.
What is Sterling's first name? Sterling? Sterling, the government official. We can check on them, they say they put something on paper. I don't know. Something like came out to it. Try that stuff up small. Gabriel, thank you. That green came in handy today. Lucky charm. You know, I covered Tory Lane's trial in California. He came to court in a green suit. It worked for him.
Did he end that?
Yeah, do you have your recommendations? Appreciate it, man. I ended up walking out, like, everybody's gone. Yeah, it is. That's nice, especially when we gotta look all nice. You guys are. Okay, good. You don't have a list about what term? We're still making out with you. I don't. You're you don't have. If you want one, right? I would rather not have one at all. So if y'all want one, give us some stuff. All right, then we'll talk about it. All right.
Get back over that way.
I guess so.
Tell you one thing, you have these things on for me. Better than last.
That's why she looking down on mine.
So for 44. Let's see. Where you at? 13.
It's a range back.
That's it, perfect.
I don't. Oh, is it good?
I'm sure you'll sexy it up. It's getting there.
I didn't let Mr. Renner. Got a car. Chris?
Second row back for. Second row back for.
What's that?
Did you have a car?
I never get cards anymore. I'm gonna hand write it out for you. There's only people that ask for court orders. It costs money to get them cards.
I haven't used one in 10 years.
See? Huh?
Pretty soon people say, you
I
have
don't
a
know why
QR
it's not
code? That's a good idea. I should put a QR code on a business card.
That work for people.
Yeah, well, who doesn't nowadays? Or mine. Where are you going? I bet you're going good on Thursday. Like a man. We had a great dinner last night. Waitress asked what he wants. That's right. He said,
I forgot to put the name of my firm, so I put it down below. That's the name of the firm. That's not my fault.
Handwriting, this is
Catch your eye. KACHOUROFF.
Okay.
Are you the court reporter? Oh, okay.
She didn't say yes right away this week.
Thank you.
Say this week.
Yeah.
She said it was
his job isn't to form an opinion, his job is to work with facts.
Can you thin me out a little bit on the photos? Can you thin me out a little bit?
I did that already.
Okay.
Hey, how?
Say hello to you.
Man, she can't get past her.
Nice to meet
Like that?
I did,
And she won't, you know.
and that's currently going.
I mean, that's too bad. Look, she came here and argued this for self. That says something.
Okay.
Yeah. The fact that you're allowed to
Really?
criticize the state's case against you.
They just sent me a text and it's like.
Really? Because it's red.
Tell me what they said.
Okay.
I'm an adult.
Let's go back to green. I can get to go green.
There it is. There you go. Is it supposed to be green? Yeah, it is now.
Here's talking shit.
It was on red.
Yeah, it was, it's red is on, green is on.
It was off.
It was on red. Yeah, it's been red.
That one might be behind
over there.
behind this.
It's that one.
Scott, it's okay, you just go back there, you tell them I said what I said.
No.
No.
So but red is off.
Yeah, red is off.
Okay, thank you.
When it come back,
Thanks, man.
come back there.
Let's get through this.
Yeah, but that doesn't mean. It's like Devo. When they come around, I'll be quiet. When they leave, I'll be talking.
Yeah, I don't look at my phone, but he was texting me the whole time. This thing goes on sound.
I knew it was good.
I just say it.
Is there a good number?
Bring them, man. As soon as I get back to my phone, you know what I want.
Oh, there we go. Oh, no, it repaid. It just wasn't green again.
I was nervous about that. Yeah,
I was staying on it. There's all that you got.
Oh, thank you. Thank you.
I'm about to say, if any obligation,
I wonder if that was off.
No, it's off.
and you know why, right?
That.
This side, this side. When you.
This is corporate tax.
So.
It just put me in a mindset. It's not something I think
So does that count as the?
It's not.
That's all. That's funny.
Yes, David. Well, I mean, this is.
This may be more like a law school.
Hey, you need something?
It's an issue.
But I told him to try, because if we get that. It's gonna be one day. He's talking over here. Danny keeps trying to put me in here. For dinner.
It won't turn off. See it turn like. Last time.
Until this Friday. Stands at 64. I was gonna be a problem. If I get my heart healed. Okay. Litigation nowadays. Why did you try to do somebody said they can't. Yeah, Dana. Hey, good morning. So it's still. Not as you, Rex. Listen. Oh, Carson. I know you was on there. I'm like, I remember you saying that you want to cover it, but I thought you was covering the actual trial. So that's what you think of. Listen. There's one thing I can say. It's not good.
They all money shots. One thing I say, I never dismiss what you do. I feel like I'm gonna go live and talk about it. I'm gonna go live and talk about it. I never dismiss what you do.
Okay, yeah.
And one thing I learned about this quickly is that we're gonna walk with people we don't like. Personally, you got some issues. Go to the
Make 1 million videos. Hold on,
listen,
I got you. I want you.
Get your feet by coming past the bar.
Okay. Too much. I was trying to get in trouble anyway.
Oh, you were.
All right. I was waiting for you to chime in.
That's my whole style, separating everybody with long hair. Yeah. I think I'm tired of short.
Yeah, clip on.
So we turn around. One thing I don't know is I have not learned how to do a task. Then
Good thing, George.
we said mix.
Are you instrumental? Not instrumental. He's instrumental.
I know what part of
I was raised in the church press. I was excommunicated. That's it. So I don't know how to. Because it's not the New Testament. So this one's in Michelle. So that's always sounded excellent. Yeah. Mr. Calls. It's unbelievable. When it's bad, it's unbelievable.
especially if I'm leaving. Oh,
Oh, yes, great.
that's awesome.
I'll be happy to live.
Oh, yeah, good. Yeah. Oh, Sunday morning, Sunday night. And then it was just as I am 30 times over, wait for somebody. So you might go like this. First number 6, I go up the aisle. He's going. He's going.
Just as I was allowed to.
Go home.
My wife went to parties.
Quite different.
Yeah.
Hey, you guys know if you want to talk outside the cameras, we'll have cameras on. How do you think things went today?
How do you think things like go?
Oh, is that directed to me? Oh, I'm not answering. He's on the road. Yeah, right.
I used to go home and see my daughter.
Guess you go home for Thanksgiving with
Beautiful over there.
It's supposed to be like. It's a long time. They're trying to avoid all of they're just waiting on us. Sure.
I'll go here all that. You got wasn't out front all that.
Because out here.
He's living tonight.
Yeah. No way.
I think they're different, so I cut my head in the ones. I hope they're not, I need my very much for their way.
If you work at the Sally Port entrance. Just drive in. Yeah, it's got, you like the game. I don't like the game. Sally Port means. Drop the gates on. That's right. It's not there. They're not trying to anger him.
Place flying right. Huh? Yeah, to get reimbursement. I strike all we have.
He's been.
I want to tell them, you thought we could do the lead bar today, just for the record.
Yeah. I think we had that live Monday.
Yeah.
It was cold.
It's not on.
So what? That's what.
It does. How much can I make this? How much more time you put this?
This is. I'm not a lawyer.
Green is not. Green is.
His shirt is trending on the internet.
What's that?
His shirt is trending.
My shirt is trending?
His shirt is trending.
Who's?
Mine? No.
Harris.
Yes.
My jacket is trending?
Your jacket is
Yeah, they
trending.
like it.
Oh, my jacket's trending?
I let him borrow it.
On Twitter, right? What's it trending as?
X formerly known as Twitter.
Lucky Charm.
Lucky Charm? That's nice, that's dope.
Yeah, that's better.
I got some more, don't worry.
Yeah, we can't say anything this goes on.
Yeah, I actually got mine. You're not gonna use it. Close, look close to it, so you go.
Yeah. Yeah, it's like.
That's gonna set off an alarm.
1,000 notes, I guess.
That's work.
Court will now come to order. Remain seated. Okay. All right, we remain on the record, and I've been provided with a proposed modified bond order for Mr. Floyd by the state. And was there anything for me to review from the defense?
Yes, Your Honor, I did see their order. We have one, just a few bullet points that we felt.
Okay. Can we get do we have an extra copy? Can we print off another?
Well, are we able to see those recommendations in defense?
Sure.
No, well, yeah, I haven't seen those. And if we could give I think there's a good bit for the defense to consider and digest here. But I don't have a copy. Well, the state's looking at the defenses right now. Okay. Yeah, I'll take. Did the defense get a copy of the state's proposal? Okay, that's going to take a minute to review. So while you're doing that, and we might still just need to wait until we can actually discuss this in depth for a few minutes here. But I'll just note for the record, the defense proposal here is handwritten that says no tags, no DMs, emails, texts, or calls. No Ruby or daughter, but can respond if Ruby says something about Harrison. State provides a comprehensive list of witnesses, but Harrison can respond if mentioned by a witness. No statements by the state that criticizes Harrison. Okay. You think we're going to dive in?
I think we're ready to dive
Okay. All right. Well, let's use the state's modified bond order as our working copy. And we can just try to go through this paragraph by paragraph. As I read it, 1 through 9 on the first page are essentially duplicative of the original bond order. Any concerns with 1 through 9?
Yes, Your Honor. Specifically, I don't believe number 2 and number 5 were included in the bond order. Those two are different.
There was he has to report. I don't know if I brought my original copy out.
The only reason why I say that is he does report it.
Yeah, that one does seem familiar. Okay. You probably don't think
Okay, yeah, that's not.
Okay.
Travel back and forth. Okay, right. Then number 5 shall have no contact. That's different than the order.
Sure.
I don't think that's appropriate. I think the issue here is shouldn't be, well, we obviously, we don't want him to make statements that would inflame folks one way or the other. Go after somebody. That's the intimidation one. That's too weird. But I think that no contact order, almost like a protective order. That's a little bit extreme. And if the president were to call him, he couldn't talk to the president because this would be a no contact order. The president's order doesn't have a no contact. I think there needs to be some kind of a carve out.
Hold on a second. Just remember, y'all, we're on the record, and so we need to make sure that we're speaking into the microphone because our court reporter is remote. Okay, so just to note, so originally we had as shall not communicate in any way with any person known to be a witness or a co-defendant except through counsel. So now that has essentially kind of been consolidated to make it very, very clear that it's just no contact with any co-defendant witness or anyone specifically named.
And we believe this is in defendant Trump's motion, if you want to pull it as part of your record, that.
Mr. Floyd, it's not your turn. So it's in the co-defendant's bond order.
It is in the co-defendant's bond order.
All right, so Mr. Kacharov, is there a specific witness, co-defendant, or person named in the indictment that you think there should be a carve out for?
First of all, for those that are respecting counts 30 to 31 for sure, that would be Stephen Lee, that would be Trevion Foodie, unindicted co-conspirator number 23, who we believe to be Harrison Douglas.
All right, but just so I'm clear beforehand.
Remember, it was no direct or indirect communication about the facts of this case. This is absolutely no contact period.
Sure.
So that's the difference.
And so you're saying that the difference here and what's needed is that Mr. Floyd should just be able to casually keep in touch and stay up to date just on a social level with these 3 individuals?
No, I mean,
if it's not about the facts of the case, I mean, were they personal friends before this indictment?
No, I don't understand the difference now. No contact versus communicate. What does that mean?
I think it's just making it very explicit. No contact.
Can't shake his hand. No, that's no contact. Well, that wasn't in there before. That wasn't any part of the allegations of the state, and I would object to that going in. I think that's just a bit onerous for the occasion.
Well, onerous in that, how does it change what he's already been doing the last, what are we now, 4 months? I understand your point, but what I'm saying is
it's communication contact. Because if it is, we're being duplicative in the court order. You know.
I could say there's sure, I could see that there's some overlap with 5 and.
If there's a specific concern, like you don't want him to be contacting Ruby, fine. Don't contact Shay, fine. I don't have a problem with that. We're not interested in contacting those two folks.
Your Honor, may I speak? It is typical in bond orders that co-defendants are not allowed to contact each other, and they are clearly co-defendants in the case. And so this is not an unusual request.
All right.
She wasn't there before.
Sure. Noted, but it is a very standard condition. And I would say safe to say almost every single case. That being said, I do wonder, is there any need now to have 11, 12, or 13? Or do we think 5 pretty much swallows those?
Your Honor, we want to make sure there's no misunderstanding here. And so we'd rather you make it perfectly plain. If you think it's unnecessary, I certainly don't want to be back here in 2 weeks because it was unclear, contact, communicate. So we think both adjectives are necessary since.
All right, Mr. Katrov.
What this does is effectively muzzle him from saying anything. Nothing about the case whatsoever. And I think that's not appropriate. I think to understand what the issues are. He can't do this now. He can't even say anything on social media.
Well, where do you see that? So now I guess we're getting more into the more substantive new additions from the state.
Like number 10.
Number 10, we have.
I'm adding the contact provision now as well. The defendant shall make no public statement of any kind concerning any co-defendant or witness in this case or concerning any person specifically named in the indictment. So beyond witnesses, even, including himself, maybe. That's the other part of this. This shall include, but it's not limited to statements in books, statements in newspapers, statements in magazines, statements on television, statements on radio, podcasts, YouTube, promo, or any other commercial or self-published media. I think that's not appropriate. I don't think that's not designed to remedy what they complained about originally. I handed you a list that I thought was the short list because that's the remedy that we thought the court would employ. So I have a problem with that. And then the second one is number 14. It's just way too restrictive. Condition. This as a bond condition. But the defendant shall make no social media posts of any kind, whether public or private, concerning any co-defendant or witness in this case. I think if we just had the original bond order, you can add the no physical contact with any witness. That would clear that up. And the communication part, you can add in no collusion with any witness. But in terms of him and in the list that I suggested to you, you say nothing about Ruby Freeman unless she has a few lawsuits pending. If she were to say something, I would of course vet whatever was going to be put out there. But the idea being that he could respond and say this doesn't find this to be true, or he finds it to be true, or what have you. So I don't think 14 is appropriate because it's so restrictive on social media.
And again, give me specifics. What is it exactly that you think he should and wants to be able to do that 14 precludes?
If he wants to get interviewed by a reporter and to talk about how this case came about, what he did in this case, I can't believe the district attorney would object to that. They'd probably watch it and catalog everything he said. Or if he wanted to get on social media and say, Miss Willis is not a nice person. She did this, and she doesn't care what he says. She said that. But if he went on there and said, what she said about me in this case is not true, or what the evidence that I've seen on the internet concerning X, Y, and Z is not true, he should be able to respond to that. Otherwise, you're just muzzling him and stopping him from talking at all. That's what the state's order does. They want to muzzle him.
Ms. Willis.
Your Honor, this bond order does not mention District Attorney Fonnie Willis at all. I've stated on the record, he can say whatever he like on any post he'd like about me. I have no value for what he says, and I'm threatened every day anyway. So that he posts and I get threatened some more, that'll be what it is. I've learned to live with that, and I am a public official, and the voters elected me here, and I put myself in this position. That does not give him the right to contact co-defendants or to intimidate other witnesses. And quite frankly, it's really in the defendant's interest to shut his mouth about this case because it can and will be used against him.
Should be complaining. So
the complaint is the harm that it does to the witnesses and the victims and the community.
All right. We're going to take turns. And the one thing that flagged to me, though, was whether this is going beyond the facts of the case as well, because one of the conditions here in 10 is shall make no public statement of any kind concerning any co-defendant. And so essentially, does that mean the expectation is Mr. Floyd, who apparently wants to be a very active voice publicly, does that put him on the sidelines if he wants to participate in dialogue about the 2024 election? Is that intended?
No.
Because one of the co-defendants would be a candidate in that election. And if you mention the 2024 election, is he not mentioning that co-defendant?
Like to add the sentence, he can promote defendant one as a candidate.
I guess what I'm getting at is before it was tied to kind of the facts of the case. And so it seems like we've gone a different direction in this one. And what we can also do is this one is more of a broader order. If we need, I would feel comfortable signing this right now as a provision to get us through today and through the foreseeable future. And if we need to come back and consider argument to modify, we can do that. I don't really see the harm in having such a blanket restriction in place for the next week or two.
Your Honor, the only thing that we would ask, because we want to make sure that they read it, is in exhibit number 16, provision number 16. That is something affirmative he needs to leave this courtroom and do. 12 hours, we believe, was generous. I don't see why it can't be done in 30 minutes, but we wanted to do that. I wanted to bring 16 to your attention.
We have no problem, although 12 hours is a bit extreme since he lives in Maryland. He's going to be traveling for the next several hours to see his family. We've got the holidays coming up. You're not going to have any trouble with that, Your Honor. He's going to be deleting those posts. That's not an issue for us.
Well, I mean, theoretically, he could just go in the next room and it doesn't take very long to delete a post.
It's actually in the car.
Okay, but
I wasn't sure.
Yeah, I don't think deleting a post is all that onerous. So bottom line, am I hearing there's no defense objection to 16 as written?
I have no objection to
that. Okay. All right. I think that, again, I too often I think we run into problems if we all collectively are rushing. So I'm fine to sign this as is today. And I would be happy to entertain a second modification once we've been able to digest this, to consider it. And we can either hear argument, or we can do it through briefing, or we can even just do it through email. So,
respectfully, Judge,
sir,
why don't we just have a one-line order until the next hearing? He stays off social media, period, until the court has a chance to.
Well, this goes a lot further than just social media. And again, I think this is a comprehensive order. But I also still want to respect the general, again, like as I mentioned before, a defendant's general right to criticize and to proclaim his innocence. And also to have, well, and that's what I'm saying. Well, under the terms of this order, he can do it without mentioning co-defendants, witnesses, or unindicted co-conspirators. So it'd have to be in broader terms. If we can fashion language that is more of a carve out, we'll work on that. But I think for now, in the short term, based on what we learned so far today and the prior history, at least for the next couple weeks, if not week or two, it'd be this.
Okay.
Thank you, Your Honor. May we be excused?
We also did one more thing. Sorry. Can we get a witness list? No unindicted co-conspirator number 23. Unindicted co-conspirator. I don't know who those people are.
It's in his discovery, but we'll point him to the right page.
I think the indictment co-conspirators had already been disclosed, as I understand it.
They have been disclosed, Your Honor.
All right. All right. I'll let the parties work that out. But for now, Mr. Floyd, you have a copy that's been provided by the state of this modified bond order. I'm letting you know that I'm signing it as written by the state, and it may be modified again in the future. But for now, everything in this bond order is it going to be in place upon signature, and you'll be expected to abide by it. Is that understood? All right. Thank you, Mr. Floyd.
John Morris. Yes, sir. Would you give me a quick Yeah. I'll get it to Mr. Rubin. Okay.